Well, legal expert Mpumelelo Zikalala joins us now for more. Good evening and thank you for joining us here on Late Edition.
Good evening to you and also good evening to our viewers.
Now, the EFF wants the South African police to open a criminal case against Nkabinde. Is this viable? Is it correct?
Yes, it is. Remember that in South Africa, where the common law, and under that common law, there's a crime of perjury, which is lying under oath. So if they can be able to prove that here's a person who has been sworn in, they've provided information which is incorrect, then that crime of perjury can then be pursued. Obviously, the law enforcement agencies will still need to do their investigation. The docket will still need to go to the NPA, and the NPA will then determine whether it's viable for those prosecution to continue, and then the process can be done and dusted. But they will need all the information of the individuals that were there, the complainants and the person who's being accused themselves, so that they're able to get a response to see if there's anything that can be prosecutable on this matter.
If he is prosecuted and found guilty, what would the consequences be?
Well, it can be an imprisonment term, it can be a fine, it can be both. If you remember the case which was held against the former Minister of Social Development, Ms. Batabeli Dlamini, it's the same type of process that you remember when it came to her. I think it was 2 years in imprisonment or payment of a 200,000 rands fine. So it's quite severe and a serious crime. The intention behind being, don't waste our time as people who are going to call you and request information or evidence which is placed under oath. Also understand the importance of what you are saying. So if there's any time wastage, if there are any misleading which is going to take place, especially with a very important committee taking place in Parliament and a very important subject matter which is being discussed, we don't have time to sort of not provide information which is accurate when you've been given an opportunity to sit down with the evidence leader, provide that information voluntarily, and then attest to it and say this is actually true and correct. So if you're going to waste the time of Parliament and also the financial resources, then consequences are going to be there. And one of those is that a common law crime is going to be opened against you, and that is being perjury.
How difficult is it to prove that he has lied or hasn't lied? How difficult would that be to prove?
It's not that difficult, because all you need to prove is that the statement was given under oath and provide instances in which the statement was done. Now, there are two statements or two submissions that are here. Remember that there's a written affidavit that was submitted earlier to members of Parliament. Now, on that one, I would guess that all the pages would have been initialed. It would have been signed by Mr. Nkabinde. There would be a commission of oath stamp that is there. On that alone, that means that all the information which is provided there was given under oath and is giving the assurance that whatever that is stating there is the truth. If there's anything which is not the truth on that statement on its own, then it could be charged. So all you need to do is to then say, let me verify the two. What happened on this date? Can I be able to provide information on maybe, for example, the calls? And you'd get your section 204 a request to look at the cell phone records of Mr. Nkabinde and the other party, and then it's easy to determine who's lying between them. And then the second part of the submissions, which was made today, when he was actually giving his evidence, if it's actually found that after being sworn in, there's certain information that he provided which was inaccurate, again, you can go on that one and say, I'm charging you again of 2 counts of perjury, and the second one is that you gave us misleading information. So it should determine on the investigation of the law enforcement agencies as which one it would be more credible, and simply go with that one to court.
Are there any similarities or parallels in Nkabinde's testimony and Mkonazi's testimony?
Well, I think it would be difficult to make that determination now, especially when his evidence has been deemed to be non-valid or not acceptable. So it would seem as if at the second session, only one can be able to make that determination. But what can be noted is that when it comes to the important elements, there is a confirmation from both parties to say there's communication between Mr. So-and-so and the minister. Yes, I was there, so I was privy to all the information that is there. So he's quite an important witness to then tell us or tell the members of the community to say, how did the ministry work? Because if a very important individuals there. You are the communicator. Without you, that office will not be able to function. You must know what sort of programs were being made. You must be privy to certain decisions. You are going to be privy to who the minister meets and who does not, who do they not meet, and reasons for those communications. So his evidence is quite crucial, which is why I guess even the committee members felt today we could continue with you and listen to information which may not be accurate, but would rather have a much more cleaner process, give you the time to go and say, make sure that when you come here, you've got an accurate statement so that if we want to quiz you and want to extract information, it's going to be accurate information.
Thank you so much for your time there. That was legal expert Mpumelelo Zikalala chatting to us this evening.